Thank you all for joining in today. A leading light in arbitration, working at an elevated level, undoubtedly one of the best field. These are not my words, but this is Toby's profile on Legal 500. As a barrister and as an arbitrator, Toby has regularly advised and appeared as a counsel before English courts, and he has a commercial disputes practice where the sun never sets. As a former MA and a BCL student from Merton College, today Toby is here to share his journey and hopefully discuss with us his secrets to success. To you, Toby.
Thank you very much for that introduction, and thank you all for tuning in. I should just make clear that I had no part in writing that part of Legal 500, but I shall now go and check it. I think my topic is a fairly general one, and the idea is to talk to you about some inside perspectives on international practice. I'm going to speak for around about 40-45 minutes, I think, and then leave some time for questions and answers. But this can be free-flowing, so please do feel free to raise points as we go along, or raise any other questions afterwards, whether related to what I've spoken about or not. And also, this is a talk without slides, so it is going to test your focus and powers of concentration, because you'll just be looking at me. The summary of the talk is rather broad. I'm going to break it down into a number of points. I think the starting point is to observe what is attractive about international law and international practice as a field that one might want to focus upon. When I was studying at Oxford, which was in the last century, international practice was always very, very attractive. I always saw it as a sort of fusion of law and international relations, as well as a bit of foreign travel peppering it. And that is really the essence of it, actually. It is very, very different to domestic practice, and it's very much more flexible, and it's much less defined than domestic practice. But what that means, I think, when you are a student, is that it's less straightforward as to how to chart the landscape of international practice and how to find a way through to it. What are your options, and how is it that one might actually make one's way into it? So 3 separate topics that I'm going to look at. Firstly, very briefly, the landscape of international practice, what options there are in the international field. Secondly, to talk a little bit about the actual nature of practice in specifically international arbitration, putting aside theory, putting aside textbooks, putting aside everything that you're taught in lectures, with all due respect to everybody who's teaching. What is it actually like in practice? What are its key features, and how can you best equip yourself to succeed in the field if that's what you are interested in? And then thirdly, I'm going to talk about the virus and about the impact already, the massive impact already of COVID-19 on the way in which we are practicing cases now. So that is the menu, with questions and answers perhaps at the end. So firstly, the landscape of international practice. I remember when I was studying international practice generally, specifically public international law, but many other offshoots of international practice seem to be a pretty rarefied area, pretty much the preserve of international law professors, who at the time were pretty undiverse and pretty ancient. There was then, I think, a perception that if you were not an international law professor, the only way you could get into international practice would be to join a shiny major international law firm. And indeed, we were, as students, regularly wooed by international firms and glossy brochures who would talk to us all about the world of international law and give the impression that that was the only way into actually practicing in this field. In truth, the area is much, much broader in terms of substantive areas of practice. And it is also a much more diverse structure in terms of the profession. There are many other ways into it and many other ways of practicing it. Firstly, in terms of substantive areas of practice, one can run through quite a broad range of different types of international law practice, from the pure public international law, interstate conflicts, work before the International Court of Justice and international tribunals, and other tribunals such as UNCLOS, Law of the Sea, to international criminal law, for example, work before the International Criminal Court and special tribunals, work with international institutions, trade work, WTO, and then amongst them is international arbitration and other forms of international ADR. So actually, it's a very, very broad field, and that's just a sample. There are many, many others. So when you think about the prospects of practicing beyond your national borders, doing something cross-border in the international law field, you should keep your scope broad because there are many, many different options. And equally, in terms of the structure of the profession, this is not just the preserve of major international law firms. There are many small firms now specialized in international law, boutique firms, non-English firms, non-US firms, and importantly, also the bar. And I think that is worth emphasizing. There is great scope for independent practice in international law. And that means not selling your soul and spending any number of years working in windowless rooms, taking no credit, and filling the pockets of partners. That may be a slightly polarized view of international law firms, but there is a lot of work, even at the bar, different bars around the world in independent practice. The bar was often seen as very domestic, very conservative, traditional, full of leather sofas and creaky floorboards and chambers tea at 4 p.m. But things have massively changed. The bar has reinvented itself over the years, and it's transformed in such a way that it now accommodates very, very significant international practice. Commercial practice in London alone, before the commercial court, sees a constituency of over 80% foreign users. But more importantly, the bar is the home of public international lawyers and people specializing across the field of international law. So that is just to park that on your radar when you are looking at the options. So my focus is international arbitration, all types of international arbitration, and that's what I'm going to speak to you a little bit about in terms of where international arbitration is as a practice area, where it's developing and how it's currently being molded by the current events. International arbitration is the single most significant form of international dispute resolution now. It has been for many years, and it continues to be. It is a system upon which international economics really depends. That is, in the pre-virus days when we used to have an economy, it ran because of, in large part, the ability of parties to agree to a form of dispute resolution, giving a binding result, aside from national litigation. And that has always been international arbitration as really the only available option. Over the years, that's meant that arbitration has given rise to a mass of cases year on year, thousands of commercial arbitrations that are known about every year right across the globe, representing disputes between people from all different cultures and systems. There's been a rush over recent years to enact more and more sophisticated arbitration legislation. There have been more and more international arbitration institutions and centers that have been established. You need nowadays, for credibility in this field, to know all your acronyms, whether it's ICC, LCIA, SCC, HKIAC, AAA, etc. Every country will have at least one international arbitration institution, some more established and successful than others. And all this activity has given rise to a specialized bar. That is now a field of practitioners who are not just litigators, they are specialist international arbitration counsel. And that's not just in England, not just in the US, it's right across Europe, and increasingly it's through Asia, increasingly in Africa. It's a truly global system, manifested again in the pre-virus days in a parallel international system of international conferences. If you ever look at this field and see how a lot of people spend their time, it is attending any number of international conferences in ever more exotic locations. So there's a huge focus, practitioner and academic focus on the area. And of course, university courses, some of which you may be taking, which have also expanded significantly over the years. So if one then takes a step forward to look at the nature of arbitration, I don't know how many of the people participating are studying it or know about it. So here's just a snapshot as a precursor to what I'm going to talk about in terms of current practice. To understand arbitration, you have to plot it on the spectrum of alternative dispute resolution. ADR goes from informal to formal methods. Informal, the most informal would be simple negotiation, and then that goes along the spectrum to something more formal, such as mediation or facilitated negotiation. It'll end up in court, which is no longer ADR, but simply good old-fashioned dispute resolution. And between mediation and the court end is arbitration. It's distinct from all other forms of dispute resolution because it ends up with a final binding resolution, whether you like it or not. So it's dependent upon consent, but once you've consented, you are into an effective process that will give you something akin to a judgment. And because of that finality, it has been the only option over the years, really, for international business people to use and to regulate international economic activity. But when one says arbitration, it's actually an umbrella term because it encompasses a whole range of processes that actually don't look anything like each other, but they're all arbitration. You can have arbitration from the simplest, most basic dispute. It could be a rent review process of looking to see how much a rent is, up to the most sophisticated international claim. It could be an interstate border dispute. It could be a massive construction dispute, foreign investment disputes, could be maritime, could be construction, insurance, reinsurance, sports, Formula One, so it goes on. Each of those areas has given rise to a process that doesn't look like the process in another area, but it's arbitration. So the common definition that links them, which is the simplest definition of arbitration, is simply an agreement between two or more parties to confer authority on a third person or tribunal to resolve their dispute finally. That's all it is. And of course, it's grown and developed into these range of very specialized areas. The reason why it is so important and so attractive, or the reasons why it's so attractive, one must focus on. Now, here you will read a classic list of advantages of arbitration when you look at the textbooks. This is what's regularly taught at university. You choose arbitration because it is an alternative form of dispute resolution that's alternative to court litigation. And it gives you, supposedly, according to the textbooks, a process that is faster and cheaper and procedurally more flexible and more expert than court. It's a process that you can mold yourselves. It doesn't have to look anything like court. It can be confidential, which is often thought to be important, and it can be tailored to the particular needs of the particular dispute at hand, unlike court, which tends to be a more rigid, pre-established system. That's what you read about in the textbooks. Of course, in practice, all of that depends. Arbitration is not always faster or cheaper or more flexible or more expert than court. And I'm going to focus upon that a little bit later in my talk. But bear in mind that on top of those factors, which generally depend case by case, there are two particular critical factors that do not change. And these are the real ones that actually motivate people to contract into this field. The first one is neutrality. Arbitration's key selling point is it is neutral. There is much cross-border activity nowadays which could never be referred to a national court because one party would not agree to submitting to the courts of its counterparty. And so if there's to be a neutral venue, the option is a neutral third country's courts, which is perfectly possible. And if that's not acceptable, then it has to be arbitration. There are many reasons why you might not agree to a third country's courts, especially if you are a state yourself and don't want to submit to the sovereign courts of another nation. And equally, there are many reasons why you will not agree to local courts of your counterparty for reasons of a lack of neutrality or a lack of familiarity or an uneven playing field when it comes to disputes. So the default is arbitration. There's nothing else. Doesn't mean that arbitration is the best option. It's rather arbitration is the only option. So that's the first of the two critical factors. The second one is enforceability, which is, of course, the 1958 New York Convention on Recognition and Enforcement of Foreign Arbitral Awards. New York Convention is the single most successful private law convention, now about 163 contracting states, which allows you, through a summary process, to have arbitration agreements and arbitration awards recognized and enforced across all those contracting states. The ability to enforce, i.e. to chase assets around the world, is again an incredibly important factor. At the moment, at least so far, arbitration awards are more readily enforced around the world than judgments. So you are better off going into arbitration than going into court if there's a chance that you may want to chase assets around the world. So those are the reasons to actually arbitrate. Now, if you put yourself in the position of counsel or indeed arbitrator, what is critical is to adopt the right mindset in order to approach this field properly and to achieve success in it. One of the most common errors that counsel make, some arbitrators as well, but counsel make generally, is to approach arbitration without taking on board these factors. And what that means is they come to arbitration as if it is litigation, often because that's what they're trained in. That's their home territory and their area of comfort. And so they come to it thinking that they will behave and they will conduct themselves in the same way as they would before a national court, whether it's the English court, the Indian court, the Singapore court, Chinese court, whichever. They will bring all the baggage of court, which in fact has no place at all in arbitration. Arbitration is supposed to be entirely flexible. It's supposed to be autonomous from court processes, and therefore it is something which provides a level playing field for people who come from different fields and have different training. The key to it is actually procedural creativity. If you want to get an idea of this, you might look at section 34 of the English Arbitration Act, 1996. It goes together with section 33. It is a non-exhaustive checklist of options to structure your arbitration in the way that you feel is appropriate. It's actually an attack on civil procedure. That was what it was intended to be. So when you run through it, you will see that everybody is given options. For example, do you want to have hearings? Do you want to have witness statements? Do you want to have pleadings? Do you want to have the rules of evidence applying? Are you going to have witnesses cross-examined? Are you going to have submissions in a different form? Actually, it's a blank canvas. There's no right answer in arbitration. There's no particular process that has to apply as a matter of law. And that is its key, its value, that it is flexible. There are cases where you will want a particular kind of procedure, and there are cases where it might be totally different. And there are cases where you might want to do something which you would never do in court, which would be impossible in court. And that procedural innovation one sees increasingly in practice, and you see a web of soft law regulation nowadays promoting that sort of flexibility. I just want to move on to one other area of practice before I then look a little bit more in detail at what this looks like from day to day, and in terms of how these cases are actually run. Up until about 1995, I could have stopped there in describing the field of international arbitration. But from about 1995 onwards, we've had a mini revolution, and that is the discovery of investor-state arbitration, or what's now known as ISDS, Investor-State Dispute Settlement. This is arbitration arising out of investor-state treaties. They were not created in 1995. Investor-state treaties have been around for a much longer period. In fact, the first one between Pakistan and Germany was 1959. But they had been concluded for all those years without anybody really reading them or using them. In 1995, largely, I think, due to a particular article by Jan Poulsen called Arbitration Without Privity, people suddenly woke up to the existence of these treaties. There are thousands of treaties, normally bilateral investment treaties, but also free trade agreements, regional agreements. And those contain arbitration, not all of them, but many of them will contain arbitration provisions. And that has given rise to a whole new area, very, very active area of international arbitration. It runs in parallel with commercial arbitration. Just to give it a little bit of historical context, the problem of using national courts to protect foreign investors has a long legacy. People have always known that this is a problem. If you have a foreign investor going into a foreign host country and they are mistreated, where do they go to have their disputes resolved? Local courts have never been seen as sufficiently neutral or adequate, especially if it is the foreign government that is the subject of claims or indeed criticisms. In the good old days, this was resolved by way of diplomatic protection, which was a system of espousal of claims by the state of the investor. And in the old days, what was regularly accepted was to go in and, for example, blockade a foreign port in order to protect the interests of your investor. And there's nothing like focusing the mines than blockading a port. But that form of gunboat diplomacy is long gone. Espousal of claims is impractical, it's rare, it is difficult because, of course, of many other political complications. So in place of that, there has grown up a system of international arbitration or international treaty protection to protect the interests of foreign investors. And that is partly, well, it is the genesis of ICSID in 1965, the Washington Convention, which set up a procedure for these kinds of claims. But most importantly, it is the product now of this web of international investment treaties, bilateral and regional. There isn't time now to go into much more detail, but what I want to emphasize is that this is quite an extraordinary area because it is arbitration not in any way that we have known previously. It's a totally different form of arbitration, yet it's very, very active now for practitioners. The way to think about its difference is as follows. It's actually much more like public law dispute resolution. A normal commercial arbitration works horizontally. That is, two or more entities are trading or contracting with each other at a particular level, by contract, by whatever other relations they have. And if they have a dispute, that's a dispute between two entities horizontally at the same level as partners in a particular transaction. Investor-state arbitration is vertical in nature. It's not about one entity bringing a claim against its counterparty. It is vertical between an investor and a host state. So it's not a situation where there is necessarily a contract between the investor and the state. Rather, it is the investor complaining that the way that the state has acted or conducted itself has caused it an injury. So the investor brings a claim against the state, criticizing or identifying the exercise of some sovereign discretion. In resolving that issue, it's the state conduct generally that's being reviewed. Now that review could have an impact on the entire population or a significant portion of a population, whoever is subject to that state policy. To give you an example, I sat as arbitrator some years ago in the well-known Bywater Tanzania case, which was a dispute about privatization of water supply in Tanzania. There was a claim by a foreign investor who had invested in that program of water privatization and was producing was actually working on a water plant in Tanzania. We as the tribunal were called upon to decide whether or not Tanzania had acted properly in its conduct of water policy. Our decision didn't just affect the investor, it would also impact on about 350,000 water users in Dar es Salaam. Now it puts the tribunal in an extraordinary position because of the potential impact of their decision-making. Unlike commercial arbitration, where the only likely impact would be amongst the immediate arbitrating parties. Secondly, the mandate is extreme, because an investor state tribunal is mandated to review all aspects of sovereign discretion. That means they can rule upon the conduct of an executive, the conduct of a legislature, and the conduct of a judiciary, because as a matter of international law, all branches of the state are part of the state. And any conduct of any of them, including judges, including a Supreme Court, can be attributable to the state and lead to the state's responsibility as a matter of international law. So you will get international arbitrators, private arbitrators, who ordinarily would be hearing commercial disputes, who are sitting upon the most sensitive areas of state sovereign discretion. Many, many examples of this. I can think of some of the cases I worked on, like Foresti in South Africa, where I brought a claim against the state of South Africa, alleging that their policy of affirmative action, black economic empowerment, which was designed to address historical wrongs in terms of discrimination, a claim that was contrary to international law. There are claims such as, at the moment, I act for Al Jazeera against the state of Egypt, where Al Jazeera is claiming that the state of Egypt expropriated its business when, in the recent or relatively recent Egyptian revolution, Al Jazeera was chucked out of the country because Egypt said that Al Jazeera was supporting the Muslim Brotherhood and was a vehicle of Qatar foreign policy trying to destabilize the state. And that's why they put journalists on death row. That is now a claim before an investor state tribunal. It's asking the tribunal to rule upon the Egyptian policy with respect to Qatar and Al Jazeera and freedom of the press. You have cases such as UCOS, a $50 billion award against the state of Russia by an investor state tribunal. The Vattenfall case questioning Germany's nuclear policy. Indeed, investor state arbitration is increasingly a barometer of world events. As you read the newspaper headlines, as things happen, inevitably now they will manifest themselves in investor state claims. And one can already see that with COVID-19. The restrictive policies of many states in order to curb infection has meant, of course, a massive adverse impact on economic interests. And there are already entities lining up to bring claims against states, which will ask tribunals to rule upon the proportionality, the propriety, the necessity of state policy on COVID-19. All of this is by reference to very abstract standards within investor state treaties and no doctrine of precedent. So investors are asking tribunals to rule on, for example, fair and equitable treatment in circumstances where fair and equitable treatment is not defined in the treaty itself. So tribunals have extraordinary latitude in actually deciding what standards to apply. Actually, the reason why treaties are not that detailed, at least early generation treaties are not that detailed, is because states often can't agree on the detail. So they agree at a level of generality. That's where they can find consensus. It's often said that the definition of a treaty is a disagreement between states set out in writing, because it's all that they can actually reach. What that means is tribunals have amazing discretion, but on very, very sensitive topics. And further, in investor-state arbitration, unlike most systems of municipal administrative law, public law, investor-state tribunals are empowered to award damages, often massive damages. UCOS, 50 billion. But many cases, the one which is often looked at as an example is CME and Czech Republic, where an award was made by an investor-state tribunal against the state of the Czech Republic for damages equal to the entire Czech health care budget for 1 year. That's an allocation of a budget without the accountability of Parliament. Public funds will be allocated by a tribunal. And that's all done in the context of mandatory enforcement, whether it's New York Convention or the Washington Convention. Now, all that to say that this is arbitration also. We're all occupied in it. It's one of the most popular areas for practice, but it's much, much more sensitive than commercial arbitration. It raises many, many complex issues. Of course, it's also given rise to a sister specialty known as Backlash Studies. That is the huge movement at the moment to reform investor-state arbitration because of a feeling of illegitimacy for a lot of the reasons that I have mentioned. Essentially, tribunals shouldn't have this power, or the process is inadequate or insufficiently accountable given the subject matter and the sensitivity. That's perhaps for another webinar to talk about the current proposals to change the process. But what I want to now look at is, having described the landscape, what is practice really like from day to day? Does it actually meet the expectations of the process, what it's supposed to be, its flexibility and the reasons that does it actually meet the demand, the reasons why people want to arbitrate in the first place? This has to be divided into two. Firstly, practice pre-COVID-19. And secondly, practice post-COVID, during and post-COVID-19. And although we have only been living with COVID-19 now for a matter of weeks, a few months, the world has completely changed in terms of dispute resolution practice already. And the feeling is it has changed permanently. So let's just sketch, first of all, the pre-virus position. The pre-virus position was curious because although I've set out a range of different types of arbitration, and especially international commercial arbitration against investor-state arbitration, for some reason, it is one particular model of commercial arbitration which has its roots in Anglo-US litigation, has taken hold. It's an Anglo-US model that dominates, or used to dominate, international practice. And by that, I mean an adversarial system which draws upon court practice, both in commercial arbitration and investor-state. Now, just pausing there, commercial arbitration shouldn't have one model for all the reasons that I've said. Its raison d'etre is its flexibility. And yet, in most major international commercial arbitrations, has been a set procedure which would define people's expectations, which people would default to naturally, with some variations, but not major variations. And then when you shift to investor-state arbitration, it's that same model that has been used, even though it's a very, very different process. Even though you might think that given its vertical nature, investor-state arbitration might require a totally different system, something which is perhaps more like an inquiry or an inquisitorial model that can make sure that a range of other interests beyond the immediate disputing parties are taken into account. So let me focus a little bit on this Anglo-US model. To understand it, one has to go back to absolute basics, which people often don't. As counsel, this is very, very important to bear in mind. Unlike a civil law style inquisitorial model, the Anglo-US model is based upon the positioning of the tribunal in an elevated, neutral, detached position between the disputing parties. So the idea of it, the basic theory, is you have parties arranged in interest groups. They confront each other in front of a detached tribunal. The tribunal is presumed not to know anything before the case begins. And as the case progresses, the nature of advocacy is to educate the tribunal. So it's not like an inquisitorial model where the tribunal is expected to make its own inquiries and educate it itself separately, or to structure how the education will happen. That comes from the parties. This was famously summarized by F.A. Mann in an LQR article back in 1977 as the principle of unpreparedness, i.e. the theory is that the judge or the arbitrator will be unprepared and you will prepare them. Now, of course, that's an extreme. There's pre-reading. It's not an absolute blank page, but that is the essential theory that then dictates how the process proceeds. How it then proceeds is through this Anglo-US set model. And the set model has a number of components. There is a written phase, firstly. People will generally put together all-encompassing memorials, not court pleadings, which are tighter documents, but a memorial which is a larger, comprehensive document that sets out all issues of fact, all issues of law, and attaches all evidence, whether it's witness statements or documents. That comes from one party, it'll be replied to, and normally there'll be a second round. In between that, there will be a document disclosure phase where documents are sought and they are provided. There'll be witness statements, there'll be expert reports. Then you move into an oral phase, which will be a hearing normally with opening submissions. And then you'll move into witness examination, cross-examination, re-examination, and then the same with experts. And then you move back into another written phase with generally the use of post-hearing briefs, further written submissions, which will draw on the transcript of the hearing and pull everything together, normally at great length, after the hearing has finished. That is a combination of common law and civil law procedure, actually. But because of the emphasis put on oral hearings, it makes the whole process pretty cumbersome, actually. In fact, the end result of this, generally in international arbitration, is a process with a lot of redundancy in it. It's a process where actually stepping back and looking at it, tribunals tend to be completely submerged with material, more material than they can possibly deal with. Although law firms with countless associates, huge teams, will draft these written memorials over a long period of time, tribunals are by themselves. There'll be 3 of them, each person, or 1 of them, each person an individual. They may at most have 1 legal secretary who can do some filing and sorting out and arranging for them. But otherwise, the burden is upon them to actually somehow digest all of this material. It is frightening. I can tell you, sitting as arbitrator, it is absolutely daunting when you have that mass of material that comes on your desk. And then you go into a hearing, and then you come out of a hearing and you get more material in post-hearing briefs. You have to amplify this or put it in context, because many arbitrators are professional arbitrators and they're going from one big case to another. And that means they're dealing with that mass of material multiple times, dipping in and out of cases. It's actually not humanly possible to digest all that material, which means to be a successful counsel, you need to present all that material in a particular way to burn on the memory of the tribunal what are the key points of your case. Otherwise, it is a hit and miss exercise. This plays into all sorts of cognitive weaknesses or biases or heuristics of any human, whereby tribunals are forced to take shortcuts in the way that they actually deal with cases. And I can tell you that there's a massive mismatch between the effort of counsel, the presentations that are made in submissions, both written and oral, the detail that's provided, as against what goes on in the deliberation room. You would be shocked if you actually found out how superficial tribunal deliberations can be. Because tribunals can't manage all the material, because their memories fade, because they're not actually assisted sufficiently. And that, I think, is also for another lecture, perhaps, where perhaps, as I'm very tempted, I'll name some names the day after I retire as to actually where the weaknesses are. But for now, I'll keep this anonymous for the sake of what's left of my career. What all this boils down to is that, contrary to what you read in the textbooks, the process of arbitration itself actually has many failings and many critics, because it's become so heavy. It's become long. It's full of delays. And all those stages that I've outlined are expensive. People are paying law firms by the hour. This is a massive undertaking, which actually is a disincentive for smaller cases to go to arbitration. It's a promotion of other forms of dispute, leads to a promotion of other forms of dispute resolution, such as mediation, which are seen as cheaper. There's much more that I can talk about in terms of the problems pre-virus. But what I want to then switch to is what's now happened. Because the world has, in the last few weeks, dramatically changed in a way that none of us could ever have predicted. The world of arbitration, like the rest of the world, has been upturned. We no longer can, at least for the main part, have hearings. The view has been, not only in arbitration, but also in court, that the world of justice cannot stop. It can't just stand still. And that's not only because of the importance to the rule of law generally in continuing dispute resolution, but also because of a fundamental uncertainty as to how long this will go on for. We simply don't know. There is now what's called a new normal. And the new normal has been taken up by courts all over the world, including the least expected, such as the United States Supreme Court, that itself has now had hearings remotely. For and courts, a commercial court in London is operating almost normally in terms of its schedule, although remotely, just by video hearings. Now, for arbitration, this should not be, you'd think, a big transition, because we have been doing hearings internationally for years. We've often had video conferences used. Often people are remote. I've cross-examined for many years witnesses over video links. What's different now is everybody is in a separate place. You're no longer in a room with anybody else, at least at the moment. And that sets up a whole new area for consideration of how the process is to operate. And the question that is now live, it's live all over the world of arbitration, is do we now simply try and transpose that pre-virus structure, which I've described, into a virtual setting? Or do we take this as a moment to reset and review that model that we have found ourselves settled into? And actually, should we now restructure it? And that's really for two reasons. One is because of the problems with that Anglo-US model, because it was not actually satisfying the needs of users or the expectations of users. But secondly, because you can't actually transpose it to a virtual environment. It actually doesn't work in the same way. And that's what we are all discovering now. We're all having hearings. I've had a number of them for the last few weeks remotely using new technology. And there are all sorts of new problems that are now being raised. They're now being looked at. They're already the subject of some soft law and regulations. There are institutions around the world, a number of them, have already produced guidelines and protocols. International arbitration institutions are now relooking at their rules. All this is in flux. So some examples. Access to technology itself is uneven. In international arbitration, one's not dealing with people from the same economic backgrounds, the same wherewithal, the same access to facilities. Not everybody has a good enough internet connection. Not everybody has access or knowledge or experience with the technology. Secondly, Having a hearing, as you would ordinarily for 8 hours or 6 hours, is difficult in front of a screen. It's a totally different experience. There are issues of fatigue, issues of time differences when you are around the world, issues of access to documents, the difficulty of having electronic bundles and regularizing that so everybody can access a document at the same time. The difficulty of interposing translation, interpretation along the way. And then there's the issue of advocacy itself, which of course is the main reason, one of the main features of a hearing, as well as the adducing of evidence, is the actual advocacy. Speaking to a camera is totally different from speaking to a person face to face. There are key issues such as eye contact. I'm now doing my best to look at you. I can't see you though. And actually where I'm looking is at my camera. Where I'd want to look is down here because I'm now looking at the only face I can see, which is Akshay and the moderator. If I want to get totally disturbed, I might look down here and I'll see myself. So I've got to avoid that bit down there because that is a terrible thing for an advocate to actually see how bad you look. Of course, there are other areas on the screen I also want to look at, like a comments box, which is over here, but I've got to keep looking up here, even though I can't actually get the eye contact that I would ordinarily want. When you're advocating in front of somebody, it's almost tactile. You feel almost a physical link, and that's when you persuade. Doing that through a camera is very, very difficult. You will also be surprised about the impact of camera positioning. And this is my top tip. If there's only one thing you remember from today, remember this. There is a common danger of using a laptop, which is down below you, and you're looking at the screen. And if the camera is at the top of the laptop and you're looking over the laptop, your tribunal may have the very uncomfortable experience of what I will describe as an up nostril effect. The up nostril effect, which is very new for us and disturbing, is where the tribunal is seeing more of your respiratory apparatus than they would ever wish. So you have to position the camera very differently and also be aware of your background, etc., etc. These are all new issues. Now, what about cross-examination? How do you cross-examine a witness remotely? Can you put the same pressure on the witness? Can you stop a witness from being coached if they're at the end of a camera on a screen somewhere on the other end of the world? How do you get the witness to look at documents if they're in a room with nobody else and find the right documents? How does a tribunal test credibility without body language? These are all new issues, and they force us to reassess the utility of hearings. It's not to say that that means hearings are no longer needed. They are needed. And each of the points that I've mentioned actually raises interesting points, interesting issues. Some people now say a tribunal can test credibility pretty well because for the first time they are getting a close-up of a face of the witness and they can see facial expressions. In a hearing, ordinarily the witness is several meters away and you don't see that close-up quite in the same way. So the tools have changed and we need to retune the way that we use them. This will also change the dynamic between the oral phase and the written phase, because for many, this actually means that the written phase will now become more important or the mainstay of the process. There's another side effect. I'm about to finish, by the way, so you can start asking questions, because otherwise the danger is I'll just carry on talking. There's a side effect of all of this, which I really want to impress on you. And this links back to where I started, which is how to get into this field and what the field looks like, and how do you start to participate. There's a side effect of COVID-19 that I think has been surprising and very positive. Apart from the reset that's happening, the side effect is that for the first time, what used to be the preserve of expensive conferences attended by a small knit, close-knit group of professionals around the world is now open for everybody, because now we have webinars. Now we have web-based discussions, mostly free of charge. A lot of us spend our times now, apart from arguing or deciding cases, by speaking at webinars. And some of the participation levels are staggering. I spoke about 2 days ago at a webinar organized in India by an Indian bar council. there were 800 participants, 800. And the kind of questions were very interesting questions, revealing a real disparity of experience in the field. But what an amazing opportunity for people to start to ramp up, to actually get into the area, not only to get educated, but most importantly, to contribute to this new normal. Because we are reshaping it now, because now is the moment where we are restructuring the field going forward. The Lord Chief Justice of England and Wales said that the courts will never return to where they were pre-virus. I have no doubt the same is true in international arbitration. But what the future holds is actually will be a product of what is now being decided. And that is a process open to everybody, including all of you. It's something that you can contribute to. You have access on the internet to the debates, the discussions, the materials. And what is emphasized frequently is that it's actually the younger generation that knows the technology better than anybody else and may well be able to have a substantive input more than those who have been practicing in the field for some time. So my message is seize the moment. This is the time to get into what is an extraordinary, exciting field, exciting because of all the difficulties and the challenges. The disputes won't go away. We see them expanding, and there will be a mass of disputes in relation to COVID-19. And so this is definitely an area of practice to look at. That's all I wish to say. Thank you very much.
Thank you so much, Toby. This was really fascinating. We already have two questions. One is from Pavel and the other one is from Katrina. So we'll probably just go ahead with the one from Pavel first. So Pavel, could you probably unmute yourself?
Thanks, Toby, for this wonderful lecture. We're all very grateful for you taking the time to talk to us. So I have two small questions. So firstly, besides the remote hearings, how did the bar and also Essex Court Chamber specifically adjust to this new reality? And secondly, obviously both litigation and arbitration are currently conducted remotely, but have you noticed any differences between the way they're conducted remotely, and do you see either as a potential winner in the long term when it comes to like being able to conduct more successfully hearings? Thank you.
So thank you very much for those questions. On the second question, do you mean between court and arbitration?
Yes. So now that the new approach is adopted, like, is there a chance, for example, for one of them to become more successful or more popular?
Yeah. But both of them, I say, very, very, very good questions. So adjustment is an interesting one, especially the bar, because the bar is not known for adjusting quickly to anything. And that's indicative of the fact that even adjusting to not wearing wigs has been difficult for some of them. So adjusting to this has been very, very difficult for some. But what's so interesting is that for the first time, ever, people have no choice. There is simply no choice. And that's what has made this so dramatic. I'm talking about a new field of practice, which is now only, say, 2 months old. So people have had to step up. Otherwise, they have no practice. Chambers generally have adjusted very well, at least the commercial bar. So the commercial bar switched into remote practice very, very quickly. And you'll see that from their websites where they set out a load of protocols. Almost all of the commercial sets have done the same thing. And in practice in Singapore, it's been the same where I'm at the moment. So that actually it has been a normal service provided. Clerks working from home, listing services happening remotely, people working with electronic documents. But the adjustment is quite a lot to do. Firstly, you've got to get to know the technology. And that's something you can learn how to use it. You can learn the platforms. What's most difficult, actually, at least I think, is working totally electronically. And that is using electronic documents, because most of us are used to litigating or arbitrating cases with paper and using the key to, actually, I can show you my visual aids here, the key to in any kind of litigation practice. There are two. There's this, which is yellow post-its, and there's this, which is a highlighter. Now, litigating without these two elements is unthinkable, but you can't in this field. You're now using Adobe and highlighting. And so that is, it may sound simple, but it's makes it very, very different, actually not having the feel of paper. So those sort of adjustments are easier for some than others. I think younger generation have found it more easy, where they're just more used to doing this. But what is remarkable is how people have adjusted. And I can see it from even the most senior members of chambers who are now busy learning Adobe and they're practicing and they're doing cases. I mean, because they have to. There are other areas of the bar that have suffered massively. Obviously, the criminal bar, and any public funded bar, a non-specialized bar has been almost decimated, actually. And with the suspension for a long period of jury trials, really hit people very, very hard in other areas of practice. Your question about between court and arbitration, I think is also very interesting because the courts are now in a similar situation to tribunals. Everybody's starting from the same ground zero. Courts have also had to restructure and reinvent themselves. I think that at the moment, I think arbitration has got more potential, I have to say, because courts are still bound by civil procedure. They're bound, and they're doing more of transposing what was the existing civil procedure into a remote world. So the white book is still the white book, whereas arbitration doesn't have that. There's no set rigidity. So in arbitration, you can, if you have the procedural imagination, say, look, we can't do it this way. Let's do it completely differently. Let's have not one hearing, but we'll have a series of separate hearings. Let's not have cross-examination in this way, but tribunal-led inquiry. So I think the potential is there for arbitration to sort of seize the moment and steal a march. But because this is a difficulty for everybody, I think it will up the game for everyone.
Thank you so much. That was very interesting. Thanks.
Kathy, would you like to go ahead?
Yes, so thank you very much for your excellent speech. You mentioned the backlash against investment arbitration, and I think that's an issue that is particularly salient within the European Union because the impact of the ECJ's ACMEA decision is still not entirely clear, at least not for some tribunals. But my question would be, do you think that alternative proposals, such as having an investment court that is also established under the CETA, is really a true alternative to investment arbitration? Or do these alternatives not rather create new problems, for instance, when it comes to the selection of judges and their independence?
Yeah, thank you very much. This is a very, very important topic and it's very complex, but I'll try and give you a brief comments on it. My sense, having practiced in investor-state arbitration now for many years, is that there are two parallel universes. On the one hand, there is the universe of investor-state arbitration as it actually is practiced. And on the other hand, in parallel, is the international perception of investor-state arbitration. The two, unfortunately, are not aligned. Investor-state arbitration, as far as I perceive it, I experience it, both as counsel and as arbitrator, is actually, I think, a very balanced, fair, and effective system. For all the criticisms or potential weaknesses that I highlighted in my speech, I think it works very well, actually. I think it is not that it can't be improved, not that there are areas of weakness, but it is an extraordinary form of international dispute resolution for sensitive issues that otherwise would have no forum. But that, in a sense, is irrelevant because over the years, the argument has progressed and it's been lost. Because in the other parallel universe, there has been a massive breakdown of trust. The perception is that the system is not sufficiently robust, not sufficiently accountable, and it's not legitimate. Now, it can only survive as a process if it actually has international acceptance and legitimacy. And it is a product of states, not investors. Investors don't agree to it. They use a mechanism that is agreed to by states. If the states lose faith, then we have to look for something else. And whether we like it or not, personally, I don't. But be that as it may, whether we like it or not, states have now lost faith. Of course, the European position is very, very specific, including the recent agreement post-ACMEA to actually terminate all intra-EU BITs. But even way beyond Europe, there is widespread distrust of the process. Now, because we're faced with that, it's been destabilized. And we need, therefore, to look for alternatives. That's the pragmatic position. Because if we don't have alternatives, we go back to gunboat diplomacy or nothing. Now, what are the alternatives? There are a range of them. They're being debated now in the UNCITRAL Working Group 3, which is working on this project to try and find some sort of standing court or standing tribunal or some sort of system like CETA or many other variations. They all will have their own problems, their own difficulties. But I think we just have to accept that that's where we're headed. Because we've lost the debate now, it's not realistic to think, I don't think, that we can rehabilitate investor-state arbitration as the system for the future. A majority of states have already voted against it within UNCITRAL. So we'll look at the next best, and the next best will have advantages and disadvantages, and that will have to be discussed another time.
Thank you.
So we have a question from Domenico. Would you like to go ahead, Domenico?
Yes, thank you. So I actually had two questions, but one has already been addressed. So I'll thank Kathy for raising it. It was on the Acmea case. My second question would be related to the use of a mediation in international disputes, because I know that recently in 2018 there has been the Singapore Mediation Convention has been adopted, and it basically enables the recognition of mediated settlements. So although it's not as popular as the New York Convention at the moment, I would like your opinion on whether we will see an increased use of mediation and if it will be eating into the arbitration market. Thank you.
Yes, thank you. Before the mediation, the Singapore Convention on mediation was seen as a softer option to arbitration, in the sense that, of course, it does not lead to a final determination, a final resolution of a dispute. So mediation is simply contract. It's parties coming together in a facilitated forum and arriving at another agreement. And in a situation where parties are confronting each other, mediation had varying success. It had a lot of success, actually, but not as much as arbitration. People would often treat it as an adjunct or precursor to arbitration, because it was arbitration that would end up in a final judgment, which would be binding and enforceable. Then in 2018, we had the Singapore Convention. And the Singapore Convention itself, what it does is it's similar to the New York Convention in that it gives mediated contracts a status similar to an international award. So it allows contracts that are the subject or have been arrived at by an international mediation to be enforced internationally through a summary procedure. There are skeptics still about whether that will have any impact, because people say if parties get to the stage of agreeing to a mediated settlement, then they're likely to pay. They're likely to comply. Why do you need to have a convention which then allows that to be enforced around the world? These are early days. There are only a handful of states who have ratified. A large number, about 50 countries, have signed the convention. About a very small number have now ratified. Early days, but my own feeling is that there is huge potential for the Singapore Convention to change this field, because what the Singapore Convention is actually doing is changing the nature of mediation. It allows mediation to end up with a product as good as an arbitral award. So I think what may happen is that parties who would never have mediated before, who would never have considered going through that process, may now do so, because if they get to the end and get to a contract, then they've got something which is recognizable and enforceable worldwide. So it will increase the constituents for mediation, the people who are willing to go for it. I think it has the potential to replace arbitration ultimately, because if arbitration is seen as overly complicated, overly expensive and burdensome and slow, then why not opt for mediation instead, if you end up with a final and binding resolution? Of course, in the hope that you actually get to an agreement at the end of the mediation process. That's one of several views. It's too early to say. But I think that unless arbitration radically changes, people are going to be looking for other forms of alternative dispute resolution.
Thank you, Toby. Do we have any other questions for anyone? Just like feel free to go ahead.
I could ask another one if you don't mind.
Please.
Yes. So you mentioned a thing that is changing due to the current pandemic. But do you think virtual hearings will persist once the current crisis is over? Or do you think once it is actually possible to have in-person hearings, that this will again become the norm?
So this is a question that everybody is asking, both in litigation and in arbitration. I mentioned the statement given by the Lord Chief Justice of England and Wales before a House of Lords committee, I think it was last week or the week before, where he said that in his view, English courts will never return in the same way to the pre-pandemic position, because he felt that the new approach will impact on procedure permanently. In arbitration, I feel even more confident that that's true. There was increasing disquiet pre-pandemic in the way that hearings were handled. I felt it myself and many other people in my situation, that one was traveling all the time, for example. You would travel across the world even for a short procedural hearing or a short substantive hearing, sometimes even a hearing of half a day, and people are getting on aeroplanes to do that. Now, environmentally, that is unjustifiable, unsustainable in terms of carbon footprint, but unnecessary, because actually people have now found that you can do this remotely, especially for shorter hearings or procedural hearings. And as people now get used to it more, and the more they do it, you will have, I think, less grounds for people to say, well, they don't trust it or they don't think it's as good. The more we do it, the more we'll see that it is as good, or it is good enough. And I think what's critical here is how we calibrate the notion of due process. One of the reasons why people have been resistant historically to using this technology is because they say they will not get due process. And parties often say, we resist, we object to a hearing being done remotely because we will not get a full opportunity of putting our case. We will not get a full opportunity of questioning the other side's case or cross-examining witnesses. And so they put down a due process reservation. That triggers a phenomenon known as due process paranoia, which is where tribunals become timid. Tribunals don't want to do anything which is going to lead to somebody reserving their position on grounds of natural justice or due process, because that might lead to a setting aside application at the end of the day of the award, or resisting recognition and enforcement. So they have traditionally taken a conservative route, and that conservative route is to say, all right, we'll do things as we have always done them traditionally. We won't have video hearings, and we play it safe. Now, this pandemic is forcing us to recalibrate due process. I don't think it can be said anymore that it's a breach of your due process rights if we've had all these hearings all this time, if we've managed to use the technology and develop it and develop our best practices. And for that reason, I think that post-pandemic, with a new sense of what are the minimum standards of due process, there will be much, much more use of technology, much more remote hearings, many more remote hearings. Whether they stay completely remote, I don't know, but that really is the point that is now up for grabs. That's what's got to be decided. And maybe give it another year, we will have formed all sorts of new ways of proceeding, which actually are better suited to this than being in the same room as each other.
Yeah. Thank you, Toby. I'm conscious of the time, so I just wanted to take a moment to thank you for the we were really hoping to have you at the faculty, but I know it's like a late night for you as well. So thank you so much for doing this. And I'd also like to thank Oren for attending, and everyone who took out the time to attend this session. So I know we can't have a proper round of applause, but let's just do with virtual ones today. So thank you, Toby.
Thank you very much. Thank you very much.
Thank you, everyone. Have a good day.